Rucho v. Common Cause 2019. This is where the Roberts Court said we could stop partisan gerrymandering, but we won't. The facts were brazen. North Carolina Republicans drew congressional maps to guarantee 10 Republican seats and 3 Democratic seats in a nearly evenly split state. One mapmaker testified, "I think electing Republicans is better than electing Democrats. So I drew this map to help foster what I think is better for the country." Not too subtle. Maryland Democrats did the same, but in reverse, flipping a Republican district through aggressive gerrymandering. Both parties manipulating district lines for partisan advantage. Lower courts struck down both gerrymanderers. They applied standards, held trials, examined evidence. The cases were manageable. Courts have been deciding partisan gerrymandering cases for years using various tests: efficiency gap, partisan symmetry, intent plus effects. Chief Justice Roberts said no manageable standards exist. How much partisanship is too much? Where do courts draw the line? Any line would be arbitrary. So the whole issue is a non-justiciable political question. 5-4 decision. But this reasoning collapses under scrutiny. Courts draw lines in political context constantly. How much religious endorsement violates the Establishment Clause? Courts decide. How much racial consideration in admissions is constitutional? Courts decide. When does campaign finance become corruption? Courts decide. All of these require line drawing in politically charged areas. The court draws those lines. So why not with gerrymandering? Justice Kagan's dissent destroyed the majority. She listed multiple standards lower courts have successfully used. Efficiency gap measures wasted votes. Partisan symmetry asks whether the other party would get similar results with similar vote share. Intent plus effects looks at mapmakers' goals combined with partisan impact. These standards existed and they worked. She also pointed out the contradiction. Courts review racial gerrymandering under the 14th Amendment. Courts review bizarrely shaped districts under compactness requirements. Courts even review partisan gerrymandering when they violate state law. But partisan gerrymandering under the federal Constitution? No standards available. The majority's real concern wasn't lack of standards. Roberts wrote that partisan gerrymandering is incompatible with democratic principles, but stopping it would transfer authority over districting from state legislators to federal courts. Translation: we know it's wrong, but we won't stop it because that would make us too powerful. But constitutional review always constrains political discretion.